Good evening. Happy Friday. This is a video from Virgo Triad. I don't know where she got the original from. Couldn't tell you. Don't really care enough to look. I'm not going to be playing anything that she did. Obviously, she is a anti-sovereign citizen channel. She's totally against sovereign citizens. I am also against sovereign citizens. I think they're silly and they waste the court's time and the people's money and resources, and their arguments make no sense. However, that being said, sometimes the court is wrong, and sometimes judges are just jerks. And this is a case where a judge is wrong and a jerk. Now, the sovereign citizen isn't right for most of this. I mean, he stumbles upon one thing that had he actually been, I don't want to say intelligent enough, but maybe learned enough to, or wise enough to understand, he probably would have had a better outcome. I don't know what exact outcome he had, but he could have had a good outcome. But the judge was a jerk. And so we're going to go through this and we're going to see where the sovereign citizen makes some mistakes, and we're going to see where the judge does something that just annoys the crap out of me when judges do it.
Will my rights be reserved, guaranteed to be reserved if I enter into this bar?
That sentence made absolutely no sense. Your rights, you retain your rights until you waive them. And asking the court to reserve your rights, I don't even know what that means. That is word salad. If, for example, you want to use someone's song, like if a political campaign wants to use a song like a Bon Jovi song or whatever in their campaign ad, Bon Jovi or whoever his agent is would reserve the rights to that song. You could use it, yes, and you have to pay us for this use of it, but we reserve the right. You don't get, it's not your song. Software companies use that. They reserve their rights. You can use it, but it's still their software. Also, in insurance cases, your insurance company might send you a Reservation of Rights letter saying that, yeah, they'll defend you. Like if you get in an automobile accident, they'll defend you, but they reserve their rights. So if it becomes clear that your policy doesn't cover this, whatever it is, then they can just back out without having, given up any of their rights to back out. There's no reliance, good faith reliance. There's no estoppel, yada, yada. So what he's saying there makes absolutely no sense.
Mr. Wood, if you don't want to recognize the court, that's entirely up to you. But if you want me to proceed today, you can come up to the podium.
So is that a yes or a no?
Mr. Wood, do you recognize the Constitution?
Yes, I do.
Then you should recognize me because I am not...
Well, then I challenge jurisdiction.
Mr. Wood, I'm not an appointed official. I'm an elected official by the people. So you should recognize me per the Constitution on Article 3. Have you read that?
So I don't know what she's going on about here. The United States Constitution, Article 3, has nothing to do with elected or appointed officials. She is a New Mexico judge, is my understanding. Having listened to this, they talk about the New Mexico Secretary of State, etc. She gets very excited saying, well, if you recognize the Secretary of State of New Mexico, then you should recognize me. So from that, I infer she is a New Mexico judge. So, Article 3 of the United States Constitution doesn't deal with elected or appointed judges. It deals with the judicial power of the United States, and nothing to do with New Mexico state judges, nothing to do with elected or appointed. Now, if you think Article 3 of the New Mexico Constitution deals with it, this is the entirety of Article 3 of the New Mexico Constitution. There is no other sections. You see here, there is only Section 1, but for example, Article 4, you see a bunch of sections. So there's only one section to Article 3, and the judicial department with being elected, vacancies. There you go. They get reelected, or they get elected, and they get retention or rejection at general election. So yeah, that's Article 6, where it deals with appointing or electing judges. So right there, I mean, that should tell you that, like, why is she doing this? Why is she doing this? This should annoy you. A judge is there to uphold the law. A judge is there to interpret the law. A judge is there to know the law and to apply the law correctly to the facts in your case. And here she is spouting off about Article 3, and it doesn't, like, what the hell is she on about? And some judges, my assumption is, of course, I'm not a mind reader, my assumption is that she's about power, and she's trying to exert her dominance over him through her wiles. She's not being upfront and honest with him. She's lying to him, essentially. Or she's stupid and she doesn't know what Article 3 means.
Well, do you have the oath of office to prove that you have a delegation of authority? Can I see it?
Sure, you can come on up and look at it.
But, well,
That's really stupid. I have never once seen any judge's decision thrown out because they didn't have a valid oath of office or delegation of authority. They do sign, at least in California, they do sign a document stating that they swear to uphold the laws of the United States and California, yada yada. But if they haven't signed that, an appeals court isn't going to throw their decision out. I mean, be like, oh, you've got to sign that, but they're supposed to be there. Just because they forgot to sign a document doesn't change anything. They're supposed to be there. They're elected, yada yada. I mean, it's not going to change anything. So I don't know why. I don't know where sovereign citizens got this in their head that that judges needed to present an oath of office on demand.
will I be guaranteed that I'll reserve my rights?
Any rights that you have today aren't going to change by you walking up to the podium.
So it's reserved.
Any rights you have will not be changed if you walk up to the podium.
So it'll be reserved then, for the record.
That's you. Mr. Wood, do you want to go forward today?
I don't want to proceed until I see documents of delegation of authority for the oath of office.
Okay.
And the officer that arrested me is not here, so I dismiss this case.
You're requesting that the case get dismissed?
Yes, because I have a right to face my accuser.
Okay.
But since they're not here,
If he's there for some sort of a trial, like if it's a traffic violation or something like that, and he's actually there on a trial, and the officer is not present, then it is very likely that the case should be dismissed. I don't practice law in New Mexico, but if you go to court on your traffic ticket, at least in California, and the officer isn't there, then your case is dismissed. So I'm assuming that would apply in New Mexico, and it does sound like this is some sort of a lower level court, but maybe I'm wrong. So maybe it's Maybelline. But he may have a valid demand there to have this dismissed, but we'll never know because, well, he's a sovereign citizen.
I dismiss this case.
Okay. Do you mind if I go over a couple of procedures with you?
And of course, he should ask her to dismiss the case. Obviously, that's the correct thing to do, because she can do that.
But all I need to know is until it's shown to me that you have delegation of authority, you can proceed. But if I don't have that, then according to pursuant to Supreme Court rulings, are you bound by those rulings?
Do you have that with you so I can read it?
And here is my this name that you guys are using are my estates too, and there's proof right here.
All right, so do you want to show me the Supreme Court ruling first? Or do you want to tell me about your different name?
I'm the executor of this estate.
Okay. Do you want me to refer?
Executor of estates. I don't get that either. Again, judging by California law, estates are something that you deal with in probate. You can be an executor of an estate would be in where someone has died and you're dealing with their estate after they've died. There's also, you could be a conservator of a person and an estate. So like if you're let's say your mom has dementia and she can't take care of herself, you might go to the court and become her conservator. And there's two parts to that. You could be the conservator of her person, meaning you get to make her medical decisions for her, make sure that she's taken care of and all the other fun stuff. Basically like as if she was your child. And then there's a conservator of her estate. And you could be person and estate or just estate, etc. And that's where you get to actually make her financial decisions for her and deal with her monies. Guardianship, it's in California, that's the same deal, except it's for actual kids. Like if your niece or something is, there's some trouble at her home and she can't stay with her parents, and you might petition the court to become her guardian. And again, you could be guardian of the person or the estate. That's just her finances. So the estate, if something's dealing with an estate, it's dealing with just the financial concerns of a person. This person needs their estate dealt with. He is a physical human being person. So, for example, in a guardianship or conservatorship, it'd be a guardian of the person or conservatorship of the person. And if it's in a death estate, then there's no person anymore. There's just a hunk of meat. So nothing of what he's saying there makes sense. Nothing.
You as executor of the state of Altonwood?
Yes.
Okay.
See, and now she's actually she's messing with him. You want me to call you executor of the state Altonwood or whatever his name is? And that's just her messing with him, and I don't really much appreciate that. The judicial canons, judges are required to be polite. That's part of, they're supposed to be polite. They have an ethical code, judicial canons, that they have to abide by. And part of that is treating the parties before them and the attorneys before them with respect. And, this guy he's wrong. He's dead wrong, but he's not being rude. He's asserting what he thinks are his rights, but he's not being rude. And she should not be flippant with him.
Okay, once jurisdiction is challenged, the court cannot proceed when it clearly appears that the court lacks jurisdiction. The court has no authority to reach merits, but rather should dismiss the action. Milo v. U.S. 505 F2D 1026.
All right. So Supreme Court never uses an F2D citation. Supreme Court, the official Supreme Court is U.S., and then there's Westlaw's version, which is like S.CT, and then there's the Lexis version, which is L or L2. Yeah, I think it's L or L2. I don't use those. I always look at the U.S. because that's the official citation to them. But if it's F2D, that means it's a court of appeals. So it's in the 505 series. It's a court of appeals decision, and it's 1020. It's on page 1026 of that particular volume, of volume 505. So this is not a United States Supreme Court decision. Now, this language, once jurisdiction is challenged, I can't find it. This is Milo v. United States. So this is, I don't even know if I really want to go into it. Here's a citation for it, 505 F2D 1026. This is a 1974 case. This deals with a failure to exhaust an administrative remedy. That's really what it's about. This is where somebody is suing they sue a person, but because that person was working for the post office, the United States stepped in because the United States can do that. If you sue an employee of the United States can basically replace that person with the United States. So you end up suing the United States. That's why it's Milo versus United States. And basically what they did is the plaintiff did not file a claim, what could be recognized as a claim. And in order to sue the United States, because the United States can choose who can sue it, it's the United States courts. I mean, they could choose whether or not to grant anybody the power to sue them because they have sovereign immunity. They said you could only sue us if you exhaust your administrative remedies. And Milo did not exhaust his administrative remedies by presenting a claim, or what the courts recognize as a claim, to the post office to get compensated for the accident. And so the court said, you don't have jurisdiction. The court doesn't have jurisdiction to hear this claim because of plaintiff's failure to exhaust her administrative remedies. So it acquired no jurisdiction over the plaintiff's claim. When it clearly appears that the court lacks jurisdiction, the court has no authority to reach the merits. In such a situation, the action should be dismissed for want of jurisdiction. So in this particular case, since federal courts are courts of limited jurisdiction, you could only sue if there's a federal question. You could only sue if there is diversity, one of those two. This is a federal question because you're suing the United States, so it deals with the United States, and the United States has sovereign immunity, and the United States only allows you to sue it if you meet the requirements that it places in those statutes. So you didn't do it, therefore you can't sue the United States, therefore the court doesn't have jurisdiction over it. There is no subject matter jurisdiction. The statutes state that you have to exhaust your administrative remedies before you can bring suit. Didn't do that, so the court doesn't have jurisdiction. Now, what does that have to do with a case in New Mexico? Probably nothing. He was arrested for something, so this isn't an administrative action, and it's the state bringing it, not someone bringing it against the state. So that's also different. So this doesn't apply. There's a real problem that sovereign citizens make. Not only do they misquote things or extrapolate from things that you shouldn't extrapolate from, but they also use a lot of dicta. They also take sentences out of context, and they cite cases that don't apply to the situation, facts, and law that they're dealing with.
So, Executor of the State for Altonwood, do you want me to read it, or are you just going to read the whole thing to me?
You can read the.
Entirely up to you. If you want me to look over your document.
Well, look, it's right here. All the Supreme Court rulings.
So, are you submitting that to the court as your
Yes.
evidence? Yes, you are.
Yes.
She just said, are you submitting that to the court as your evidence? Now, he's challenging jurisdiction, and he didn't use magic words if I'm specially appearing to challenge jurisdiction, but he's challenging the court's jurisdiction. And a Supreme Court ruling, a memorandum of points and authorities, a list of citations to cases that you believe support your legal argument are not evidence. That is a legal argument. It is not evidence.
Are you sure?
And she should know that because she's a judge.
You want to do that today?
Yes.
Okay.
But I'm not proceeding until.
All right, so let the record note that Mr. Executor of the State for Altonwood has recognized this court as proceeding over this case by submitting evidence into the court. By you.
She just lied. She just flat out lied. You should be appalled by this. This should just make you completely upset, because if she's doing that to this guy, who else is she doing that to? How can you trust her rulings if she's going to do this? Either she's a complete ignoramus and doesn't know the difference between evidence and argument, or she's a liar. You pick.
You submitting this evidence, you recognize that I have jurisdiction.
No, you don't.
You just submitted this to the court for me to review.
But you still don't have. You don't have jurisdiction.
Tell me why I don't have jurisdiction.
Because.
He was right. That did not give her jurisdiction. I mean, she may have had jurisdiction already. She probably did, but him handing an opinion from a court of appeals to her does not in and of itself grant her jurisdiction.
As an executor of this estate, this is from the Secretary of State, saying that you have to pay me $100 billion to use my name.
Okay.
And I'm first in line.
That is so stupid. That is impossibly stupid. I can't believe he's that dumb, but okay.
First in time.
Okay.
So, do you want me to give you an invoice for that?
You're reading a document by the state of New Mexico.
Yes,
And you
Secretary
recognize
of
the state of New Mexico, Secretary of State's office.
Yes, they recognize me as a executor
All right.
of this estate.
The question I'm asking.
That is something that is something I've seen, that what she's pointing out there. Sovereign citizens tend to recognize, they'll recognize the Supreme Court, they'll recognize these lower courts that have opinions that they agree with, but then they won't recognize the court that they're in front of. It's very nonsensical, and they recognize. Oh, I have this document from the Secretary of State. Yeah, I mean that obviously that is important, and the state can do that, but the state can't enforce its own laws. That's really weird.
Asking an executor of the state for Altonwood is, do you recognize that document by the state of New Mexico?
Well, that's a corporation.
Yes or no?
Well, I have this is stating that I have jurisdiction over my own. You don't have jurisdiction over my case.
Okay.
And then besides, the officer is not here, so I dismiss this case.
All right, so we'll get to the officer part in a moment. First, executor of the state for Altonwood, I want to make sure that we're on the same page here. So you're saying that that document by the state of New Mexico, you recognize?
Well, this is a corporation. The state is a corporation, and the state cannot. If it's the state is a plaintiff, then how could I cross-examine the state when it's a dead entity?
All right.
That thing, he's right that the state is a corporation, but what these sovereign citizens don't get is corporation has multiple meanings. There is corporation is just a group of people that are fungible, that have come together to form an entity, a legal entity other than that's separate from them. It's like a partnership is not a corporation because if a partner dies, that partnership is dissolved. Because a partnership means like, two people or, maybe three or whatever, but let's just keep it simple. There's two people, and if one of them dies, it's no longer a partnership. It's now a sole proprietorship. The partnership ended because one of the persons died. Corporations are different. If one shareholder dies, their shares just get passed on to another person or whatever, or the corporation buys them back, but that doesn't end the corporation. If they get a new president of the corporation, it doesn't change the corporation. The corporation is still the same entity. It just has a different president or a different CEO or a different secretary or a different CFO or whatever. So that's all a corporation is. Now, so the United States is a corporation. The individual states that comprise the United States are all corporations. Towns and municipalities are corporations, but those are different than the corporations like PepsiCo or Coca-Cola Corporation or McDonald's Corporation. Those are registered business entities in the form of a corporation that have registered with a particular state. They're incorporated in a particular state under the laws of that particular state. And it's an entirely different thing. Those are corporations that are entities that are made by the states. The states themselves have incorporated. They have done it on their own, under their own sovereign power. Whereas like McDonald's did it under, I don't remember. I think they're a Delaware corporation now, but I think they were a corporation for a different state in the past. But anyway, yeah, he's right. It is a corporation, but it's a meaningless distinction for him to make.
So now you're getting into a trial issue, and I'm still trying to figure out, executor of the state for Altonwood, if I have jurisdiction or not. And the question I asked you is, do you...
See, what I'm trying to figure out is if I have jurisdiction. But see, she was just so darn cocksure a minute ago about him submitting evidence.
Recognize that document that you're referring to that's issued by the state of New Mexico.
It is by the state of New Mexico,
And
yes.
you recognize that document.
Well, this tells me that I'm the executor.
So you're saying, based off that document that's filed with the state of New Mexico, it's giving you the executorship for this name. Is that correct?
That is correct.
All right,
it's
so
signed right here.
Do you want me to look at that?
I can mail it to you.
You can mail it to the court.
Oh, did you have the other thing that I sent to you? Let's see.
I'm not sure what else you sent, executor.
Okay, this one.
Why would you send me information if you think I don't have
Oh, I have. Do you have the affidavit?
She just said, why would you send me information if you think I don't have jurisdiction? Well, because normally the way you challenge jurisdiction is you go to the court that you believe lacks jurisdiction and you submit your legal argument as to why they don't have jurisdiction. And then that court will look at that legal argument and they'll say either you're right or you're wrong. And if you're right, they will then dismiss that case because they lack jurisdiction to hear the case. So all they can do is dismiss it. That is why he would submit something. She just,
David, a copy of affidavit?
Did you mail it to the court?
Yes, I did.
Why would you mail it to the court if you don't think I have jurisdiction?
Because to notify you, put you on notice.
Okay, so the whole purpose of your mailing is to put me on notice.
Yes, put you on notice that you don't have jurisdiction.
And today you're still with the argument that I don't have jurisdiction.
Yes, you don't.
Okay. If I don't have jurisdiction, and you're claiming I don't have jurisdiction, and you sent me information indicating I don't have jurisdiction, then how can I dismiss this case?
because that is the way it works. And a judge knows this. I don't know why she's toying with him. If a court lacks jurisdiction, the only thing that court can do is dismiss the case. We don't have jurisdiction to hear this, case dismissed. Maybe with prejudice, maybe without prejudice, who knows? And that would depend on the facts of the case. But if the court can't hear it, the court has to dismiss it.
because there's nobody to no standing. You guys have no standing because there's nobody injured. There's no injured party. There's nobody damaged.
Okay?
Standing isn't the same as jurisdiction, but whatever.
So I dismiss this case.
If you want to submit a dismissal, you can do that. If you want me to dismiss it, you have to recognize me first before I can enter that order.
Well, I can
See, now she's... So what he would most likely, again, I don't practice law in New Mexico, most likely what he would have to submit is some sort of a request or a motion or a petition to dismiss. He wouldn't actually send in an order dismissing the case because that would take an order of the court to dismiss the case. So she's just yanking him around. And that's not the role of a court. That's not the role of a judge.
I'll dismiss it myself then.
Perfect. I'm going to hand this back to you, and you can submit your paperwork in a minute. Thanks for coming in.
And see, I mean, she just acknowledges it. Oh, I'm going to dismiss it myself. She says, fine, you can dismiss your paperwork. Or I'm sorry, you can submit your paperwork to me. Like, what happened to a second ago where she was saying, well, if I don't have power over this, why would you submit these documents to me? So, anyway, that's really the end of it. It really undermines faith in the judicial system when judges act like this. And, you know, I've been practicing law now for more than 3 years and coming up on 4. And I have just seen too many judges at this point that don't take matters seriously. And this is a particularly egregious example of it. But this should get you upset. Anyway, thanks for watching. Have a great day.